second videos first. In the second video, I told you a little bit about the hearing itself. In this video, I'm going to talk about giving evidence and about challenging the evidence of other people. Not every court hearing will involve the judge hearing evidence. If the parties haven't been able to agree about things and it's clear that the court will have to resolve a dispute about the facts or a significant dispute about what should happen in the future, the judge will probably have to list the case for a hearing with a time estimate that is long enough to cater for the giving of evidence. If your court order says that the hearing is listed for 30 minutes to an hour, the judge is probably not planning on hearing any evidence, although he or she will listen briefly to what each person in the case has to say. Often the evidence will just be from the parties to the case, that's usually you and your ex-partner. But sometimes it will also be needed from other people who've witnessed something happening or from a professional involved in the case, such as a CAFCASS officer or a social worker who's written a report, and occasionally from an expert. The court hears evidence from people so that it can decide whether what they're saying is accurate, so that it can assess the parties generally, and so that it can decide on whether a professional opinion is well-founded or not. The evidence is tested by the parties and the judge asking the witnesses questions, and this is what's called cross-examination. If you give evidence, you'll be asked questions by the judge and by the other person or their lawyer if they have one. The judge will make sure that all of the questions are appropriate. If there are allegations of domestic abuse, the judge may ask questions